Sim,
Sure.
sim. Voilà.
So welcome everyone again. Thank you so much for being with us. We're having our second session of Heart and Soul of Leadership regarding canon law. So yesterday we had Sister Kelly and Sister Maren Rose with us, and they looked at what is canon law, which is so important. Sometimes we have different ideas, and we are a little bit afraid of canon law, but canon law is here to help us on this journey of holiness as well. Sister Kelly reminded us. And on that note, yesterday we looked at accountability and discretion, as well the role of the General Council, and also at alienation of property, what needs to be done when a council, a congregation wants to sell or to somehow get rid of some property. What are the steps that need to be taken? And today we will be again looking at some other aspects of canon law, and this time we'll be looking at leave or absence, leave of absence, exclaustration, and dismissal. That sometimes are confused. They are not the same thing, they are different. And so it's important to learn about it. So I am aware that yesterday we didn't start with prayer, but today we need to, more than anything, because we are celebrating the Annunciation of the angel to Mary. And that is an amazing and beautiful and foundational feast, if you want. I'm sure that many of our congregations, like mine, are celebrating these major feasts today. So let us pause for a moment. I think we are so used to this idea that God became one of us, that sometimes we lose the capacity of amazement. Christianity is the only religion that claims and believes that God, the creator of heaven and earth, of all that is seen and unseen, as we say in the Creed, became one of us. And I'm sure many of us are in touch or have been in touch with babies, and how incredible it is to believe that God became a fragile, small human being to love us, to be with us, to teach us the way, to teach us to be humans. And also, let us pray to Mary, the one who allowed Jesus to be who he was, and the one that enables us also to say a yes at every step of the way. Canon law is there also to help us to say yes, and in a special way. Mary teaches us that God's grace is always, always at our side. So I would invite us just to stop for a moment. Some of us are at the end of a journey, others are at the beginning, others like me and many are at the middle of it. So before we start this canon law session, let us just stop and ask Mary to help us to trust God as she did, to help us to experience God's love as she did, so that we can always say a yes as she did.
Mary, Sumasa iyo.
Dawa for our dead.
Maria, ina ng Diyos, mo kami ang kasalanan. Amen.
Thank you, Paula, and happy Feast of Annunciation to all of us. So today we are back again. I hope you can hear me. Okay, yeah, thank you. So today we are back again to continue with our sharing as we did yesterday. And today we look at leaves, the exclaustration, and dismissal, as much as we will be able to accommodate, because Kelly can agree with me, we would need maybe 1 month to exhaust what we are going to share today. But I will try, and I'm happy she's there, and she will also help and intervene just to make it more rich. So when we look at separation from an institute, the church envisions religious life to be a stable and a permanent way of life, and departure from it is not foreseen. And the church hopes that as much as it is possible, those who join this state of life stay in it permanently in a stable way and for the rest of their life. So it is an unfortunate situation whereby a member, for whatever reason, may have to depart, either temporarily or permanently. So departure is unprecedented and strongly discouraged, such that the stability of this state of life is protected by law. We join institutes that have been approved in the church. We join with vested rights. We are protected by the legality of this life and the oversight of ecclesiastical authority, so that as much as it is possible, we live in a stable and permanent manner. So in the case of when a member is to leave, the law of the church provides norms which are to be strictly interpreted and observed, because such a member consequently will have to change their status of life. So, with that background, if a member is to be separated from the institute, separation will only be resorted to if the matter cannot be resolved in another way. And as much as possible, there will be pastoral intervention accorded so that solution to the matter can be reached without having to resort to separation. And the matter has to be of necessity of the greatest good, which is salvation of souls. And separation is to be as a last resort. So as we look at all this, or we look at separation, some of the helpful resources would be the amended norms of the Code of Canon Law. In the recent past, the whole of Book 6 has been amended, and the guidelines that were issued 2020 from the dicastery. The document is the gift of fidelity, the joy of perseverance. And helpful are also some of the articles that authors have written in canon law journals on the topic of separation. That could also be very helpful. So before I begin, I would like us to look at some of the canons that have been modified, because this has to go into our proper law so that we are also following the procedures according to the law of the church. So one of them was the modification on 19th of March 2019, which modified Canon 694 on automatic dismissal. And the Pope, who is the supreme legislator, added another ground for automatic dismissal, that is illegitimate absence of a member for more than 1 year with whereabouts unknown. So this canon initially had only 2 grounds, but from 2019, there's that third ground that was added from the experience of so many religious who had disappeared from the institute. It could have been they had gone to other countries to study and they never came back. And only when maybe such a person would have been caught in prison or would have been caught breaking the law, then the first person they call is the superior. And they claim they are members, having been disappeared maybe for 10 years. So this was one of the grounds that was added to help congregational leaders to deal with such members who had cut off communication completely and only resurfaced when they were in serious problems. And we look at how such a process is carried out in case they are to be dismissed. Secondly, we added the change of Book 6 of the Code of Canon Law on the 8th of December 2021. And it changed, among others, Canon 695, paragraph 5. Because Book 6 had changed, and part of those norms in Book 6 were also included in the process of dismissal, such changes had also to motivate changes in that part of dismissal. So we will look at those changes one by one, but let us look at changes on exclaustration. 15th of February 2022, exclaustration was the period was extended from 3 to 5 years, of which the internal superiors now had no competence. If the member on exclaustration wanted to be away for more than 5 years, they had to now ask for approval from the competent ecclesiastical authority for diocesan bishops institutes, the bishop of the house of assignment, and for pontifical institutes, the dicastery of consecrated life. Another change that was made was on the approval of the decree of dismissal. Up to 2022, as we know, if a member to be dismissed, the competent superior had to first seek for approval from the competent church authority. Pontifical institutes, this approval was to be granted by the dicastery, and for institutes of diocesan right, this approval had to be granted by the diocesan bishop of the place of which the religious is assigned. So the change stated that now dismissal is a matter of internal authority. After the decree of dismissal has been issued by the competent superior, that is it. It takes effect unless the member rejects it in lieu of appealing for its change, in lieu of making appeal to the higher authority. Another change occurred 2nd of April 2023 on the period of recourse. Initially, the dismissed member had only 10 days to furnish recourse to the competent church authority. But it was felt that 10 days, somebody is still traumatized, they are still recovering from the decision, and may not be able to get appropriate and adequate canonical know-how in order to write their recourse to the appropriate authority. So the period has been extended to 30 days. And with that extension, the religious does not need to first ask the author of the decree of dismissal to revoke or correct the decree. They don't need to request. Initially, before sending the appeal, the member would have to go and request, petition to the author of the decree if they can change their mind and revoke it or make modifications. We now want to go, after considering those changes, which we will also come back to as we look at the processes, we want to look at what you requested for, the leaves. Traditionally, or for a long time, those leaves, we hear of leave of absence, leave of absence. In the present Code of Canon Law, what is referred to, what we could equate with that statement of leave of absence, it is referred to as lengthy absence or prolonged absence. So this prolonged absence is identified in two types. To begin with, common life is an essential element of religious life, and therefore illegitimate absence is not permitted. A religious is supposed to live in community. Whatever the structure or whatever has been agreed upon by that religious family as community. Therefore, whatever absence, permission has to be sought from the competent superior. Holidays, workshops, or some kind of brief absence, the community leader will grant the permission. A lengthy absence, which is not a few weeks, but does not go beyond 1 year, permission is granted by the major superior. For that, we mean either a regional superior or a provincial superior or a delegate, depending on the division, the intermediate divisions of the institute. There must be a just reason, and the superior is to act with the consent of the council, so that the member can live outside the house of the institute for a period not exceeding 1 year. The just reasons are to be specified in the proper law, but it is a reason that necessitates the member to live out, and for example, by the member living inside the religious house, they are not able to accomplish or to fulfill a certain necessity. For instance, a member is unwell and they have to stay in a health facility for up to 1 year. That could be a just reason, because for them to stay in the community, it would be difficult for other members to take care of him or her. But the proper law can enumerate other just reasons that are documented in those laws. There's also the lengthy or prolonged leave, which is beyond 1 year. The one beyond 1 year, the code has specified in Canon 665 the reasons or motivations, and there are 3, and they should not be added. Number 1 is for health reasons. Sometimes a member may require services or medical assistance, which is prolonged, that goes beyond 1 year as long as they are not well. So the canonical vehicle to allow them to be outside the community will be the leave of absence for more than 1 year, the lengthy absence for more than 1 year. Another motivation is studies undertaken in institutions that are not in proximity with the religious house of the institute, or in which residence is obligatory. For example, here in Nairobi, where I live, I know there are institutes where sisters are sent to medical schools and residence is obligatory. So sisters must stay in those institutions or other places of studies, of which they have to be very far from their communities. So that is a reason for allowing members to stay out. So by sending a member for studies, of which they have to reside outside the community, that assignment carries with it implicitly the permission to be outside of the community for more than a year, because they'll be out as long as the necessity remains. Another motivation is apostolate exercised in the name of the institute, but in places outside the proximity of religious house of the institute, or the necessity of the nature of the apostolates. Like I'm sure people like Paula here, she is exercising apostolate at UISG, and perhaps I don't know, it may not be possible for her to live in her own religious house. So that could be a reason, and the motivation there is specified as leave for more than 1 year. Now, there are special situations or cases for leave of nuns. As we know, nuns are to observe the pontifical cloister. So it's very difficult for the nuns to be out of their monastery. They can only be outside the monastery not beyond 15 days. And if they are to extend it beyond 15 days, the major superior can allow it, but with the consent of our council. Again, the major superior can allow a nun with solemn vows to be absent from the monastery, but not beyond 1 year, but after hearing the diocesan bishop or the competent religious ordinary where the monastery is located. So for the nuns is a different arrangement. Who grants the indult for absence? It is the major superior with the consent of the council, as I've said. But the indult will specify what is the manner of contacts that the religious on absence is to keep with the institute. Any financial assistance that the institute may deem necessary to accord the member. Details on the modifications of the vowed obligations of the member, especially the vow of obedience, because if the member has gone to the health facility or with the family, they are not going to choose one of the health persons or one of their family members to be the superior to obey. And their manner of living poverty will be modified. So those have to be specified in the decree granting absence. To what extent are they going to live, or how are they going to practice their vow of poverty and obedience? The indult is to specify the manner of accountability and to who, the expected actions and the outcome, especially when maybe somebody is out on absence due to vocation crisis. What are they going to do, and what is the expected outcome? The limits of what the member can do or not do. Are they allowed to come back to the community for everything, attend all the functions of the community or not? Negligence, this indult will now help the competent superior to assess fidelity of the member on those obligations that have been listed, so that negligence or failure to fulfill the obligations or any proof of behavior resulting in contrary witness or actions that will go beyond the permissions that were granted will justify corrective measures by the competent superior. So, what are the effects of absence? So, religious on, this is not the ones of more than 1 year, this is up to 1 year, because the religious on lengthy leaves remains members of the institute and their obligations are intact. They are still bound by the vows and subject to their competent superiors. They retain the right of active voice, and they have to be open to return if they are called back. They are to render accounts to the competent superior for all the funds received and spent. And the superiors are obliged to keep in contact with the member on leave. For just reasons, the competent superior may withdraw this permission even before the expiry, in which case the member is obliged to return to the community. The member can also ask to return back to the community before expiry of the time. Such leaves, as we've said, they modify the canonical obligations which are not compatible with that new mode of life. I don't know whether there's any intervention up to that point on leave. So, Sister Paula, I don't know whether the participants would wish to have any intervention. Yes. 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 Okay, I would request Kelly to intervene if she does not mind.
It depends on how you articulate it in your proper law and how, I mean, every situation is different. And so that's the wonderful thing of canon law, is that each one encounters the law directly. I'd like to just comment a little bit on the absences that Sister spoke of, the permission of absence for reasons of study, health, or apostolate in the name of the Institute. I think the modality is that once we're not living in the ordinary manner of our institute that it seems to be we need that permission of absence. However, how we've evolved in community life, that exceptions can be made, and these are very just reasons for not living the ordinary model of community life. I don't see them so much as an absence, because the sister is living where she has been assigned to live for her studies, for her health, or for apostolate in the name of the community. So her status is that she is fully integrated into the life of the province or the congregation, because she is where she's supposed to be. And just like any member, if they don't live as they are called to live, they will be called to task by their leaders. And if they are, if the ministry or the studies finish when they're finished the particular assignment, then they again submit to obedience to wherever they will be called. So it's a different kind of a scenario. So what is the absence to care for a family member? Some canonists are generous in their interpretation that when it's for reasons of health, the canon does not say whose health. So this is a permission that can be granted under that category. Other congregations have begun to define in their proper law how permissions to care for family members will be considered, whether it is an absence closer to an exclaustration, or whether exclaustration should be requested, or whether it can be a permission of absence granted by the community and assigning the sister to be in this place to care for her family, but also always clear what the expectations are for participation in the life of the community. Does she return for weekly community meetings? Does she return for annual retreat? Is this permission only for 1 year, and then it's expected that other family members will come and care for the person who is in need of care? But it's always to keep the communication open, clear, and welcoming, because we wish always our sisters are at home within community. How is that, Sister Marin?
Good. Yeah. And just to add, a member on absence is not punishment. It's not a penalty.
Yeah, exactly.
Yeah, it's just a situation that is not compatible with their living in peace in the community. So it should not be taken like they've separated themselves. So as Celia said, the communications have to be cordial and close and frequent, so that the member they also feel they are part of the community. And the member also should not take advantage of the leave to go and disappear, that nobody has seen them since they left. Yes. Yes.
With the permission of absence, they are still a fully integrated member in the community. They're just living in a situation different from the norm. And so the congregation is fully responsible for their care and upkeep, and the sister is fully accountable and still has the obligation of all income returning to the Institute. However that is worked out, whether it's merely a fact of accounting, that I keep my salary in an account which is accessible by the community, and I render account for it every month, and I cover my expenses out of that account, or whether my salary is except received by the congregation, and they give me my allowance on which to live. It is the same as it would be for any member of the province or congregation. There is no mitigation of her status as a member of the community in these permissions of absence. Exclaustration, I'm sure Sister Marin will highlight the difference, because that is a different kind of absence.
Yeah. Is there another question, Paula? Okay. So, just as I said, if the indult has specified the expectations, this is how you'll use your money, this is how you'll account, this is the contact of the person to see, all that specified in the indult that the member has been given. So negligence of all these obligations will now allow the competent superior to undertake or to take corrective measures. Yeah, you know, like the member is just like any other member. And so when they do not fulfill those obligations, it's just like any other member violating the obligations of their consecrated life. So the same measures will apply to them. For example, let's say they went for studies and they never came back. The canons that deal with those who have disappeared will apply to them. They went for 1 year to maybe take care of a sick parent, and the parent became well long time ago, and they just want to enjoy life. Yeah. So that is, for me, it is insincerity. It's not being sincere, because they need to come back to the community. So suggestions would be the superior, if they have come to know of the fact, should recall them back immediately. And their refusal to return back could be amount to disobedience. Yeah. Okay, leave of absence is an internal matter of the internal superior. It has nothing to do with Rome or any other ecclesiastical authority. A junior sister is entitled to the lengthy leave not beyond 1 year. If there is necessity to renew it, she must return back at the end of the first request. Yeah, and then the request can be made again. But it cannot go on forever, every year. Then other decisions or other ways of dealing with the matter may have to be looked into. If, let's say, the junior sister has to keep on going for lengthy leave for the next 3 or 4 years, that perhaps would cover all their years of temporary profession. So in discernment and in openness, other options may have to be looked at. Again, as I've said, if the necessity goes on and at the end of the year, in open discussion and in honesty, the competent superiors may have to consider renewing the leave. For perpetually professed, they may have to consider voluntary exclaustration, of which we are going to look at next. Yes. They have to be kept informed of all the matters going on in the institute. They have a right to be kept informed.
In this kind of leave, the sister is fully a member. This is not a punishment. These moments are the sister is doing what she is assigned to do, which is caring for her health, studying for the service of the institute, or performing an apostolate in the name of the institute. Just because she is living outside a normal community setting does not mean there is any kind of clear separation. The separation is only physical, okay? Everything else, the sister is fully integrated into the life of the province or the congregation, and it could be, I mean, the expectation that she return for her annual retreat, that she, I mean, not in the case of residential health care, of course, but in as much as possible with studies and with this apostolate. And if she can't return to make her annual retreat with her sisters, then she receives the permission of where to make her retreat. She is fully a member, okay? So there shouldn't be any kind of limitation. This is not a punishment, these kinds of absence. These are mutually beneficial absences. She is performing tasks or seeing to her own health, or we're seeing to her health by placing her somewhere to care for that health. It is for the good of the sister and the congregation that she is outside of the normal community setting.
Yes. Okay. Yes, yes, I think so. Yeah, I think. Thank you. Yeah. So we go to exclaustration. It is also absence from common life of a perpetually professed member while remaining a member of the institute. Yeah. So it is authorized by the competent superior to reside outside the community. And while leave is to be justified by just reasons, the exclaustration must be motivated by grave reasons. And I just request to read the canon on exclaustration, just to hear with the consent of the council, the supreme moderator, a grave cause, can grant an indult of exclaustration to a member professed by perpetual vows, but not for more than 5 years. And if it concerns a cleric, with prior consent of the ordinary of the place in which he must reside. So it must be for a grave reason. So serious that it is not possible for the member to continue living in the community. Let me talk about exclaustration of nuns later. I don't know where I put the slides of the process. I'm sorry about that. For cloistered nuns, let me just go there. The permission is granted by the major superior with the consent of council, and they cannot go for more than 1 year. And to do this, the major superior requires the consent of the council of the place where the nun will also, the ordinary of the place where the nun is to live, and the opinion of the diocesan bishop or the competent ordinary. That means when the nuns live in a monastery, of course, they are in the jurisdiction of a certain diocese. So that bishop has to be involved. The same major superior is the one who can extend the period. For a nun professed with solemn vows of a monastery of a federation, it is the federal president with the consent of the council. It is the same authority that can extend the period, but not more than 2 years. For the nuns, the period is limited, 1 year, and extension cannot be more than 2 years. So we have 2 types of exclaustration according to the code. We have the imposed exclaustration. That means the motivation, or it is initiated by the institute. And to impose exclaustration, the supreme moderator, with the consent of their council, will request the dicastery, if the institute is pontifical, to impose exclaustration on a member. For the diocesan institutes, it is the diocesan bishop of the house of assignment who will be requested by the supreme moderator with the consent of their council to impose this exclaustration on the member. I want to highlight the bishop here because my experience is in many occasions, the competent superiors mistake the bishop of the mother house to be the one competent to impose exclaustration or also to be appealed to in cases of dismissal. It is where the religious is exercising ministry, where they live. So for example, if we say the principal house of the institute, which is diocesan, is in Italy, but the member is working here in Nairobi, the bishop that is to be dealt with or to be involved is the bishop here, the diocesan bishop here in Nairobi, not the bishop in Italy. It becomes very complicated because the supreme moderator might not have a personal knowledge of this bishop where the member is assigned. And that is where it is very, very important that the intermediate competent superior, that's the regional or the provincial, where the member is, take the initiative of informing this diocesan bishop of the imminence of this process or whether it has begun, so that this bishop is not shocked or surprised that there's a certain sister of whom he is to impose exclaustration on. Then we come to voluntary exclaustration. This is where a member requests to be allowed to reside outside the community for a grave reason. And for a cleric, of course, the ordinary of where is to be informed, not to inform, to give consent that the member is coming to stay in his jurisdiction. The differences between absence and exclaustration, we are going to see them in the effects. One of them is the period. Exclaustration can go up to 5 years, while lengthy leave, the first type, cannot go beyond 1 year, and The one beyond here are attached or is attached to the reasons that or the grounds that we had specified. So the effects, while the member on lengthy absent does not lose active voice, the member on exclaustration, imposed or voluntary, will lose both active and passive voice. They can now not be appointed or named to offices in the institute or roles because of the manner of their life. Their current status does not allow them to take up those offices or to also vote or elect, or they lose both active and passive voice. They are dispensed from those obligations which are incompatible with their present condition of life. They remain dependent on and are under the care of their superiors. Their rights and obligations remain intact, however, with modifications. For example, they now lose the right of active and passive voice. It is very, very important, since the matter that motivate members to go for exclaustration must be grave. So the indult must be very, very clear, spelling out forms of accountability. If they are to retain their salary, the support to be given, agreement on health insurance, car rent, all those must be specified clearly in the indult. Whether they are to wear the religious habit or not, when they are to return, because it is not necessary that they stay for 5 years. If the motivating factor has been resolved within 1 year, then they are to return. The institute also can terminate their requested extension or the time that they had requested for. In case of the imposed exclaustration, which is facilitated by the institute, the member is not to return until the competent authority that issued the indult revokes it, because it may be motivated by a reason that cannot be resolved, or the member who gave it is not satisfied that the matter has been resolved. So it will last as long as the issue still persists. So briefly, that's what I can say. I know there'll be many, many questions on this. So perhaps we can expand it with the questions that arise from it. Yes. Okay, I will answer, but I will also ask Kelly to intervene. So what I would say is, I deliberately did not talk about illegitimate absences because I'd hoped to address them when we are talking about dismissal. But indeed, from that question, it appears the member has been illegitimately absent. They were not given permission to be absent, or they were initially given permission, but they went beyond the specified time. And it appears that there was lapse of communication up to the time of new leadership. To begin with, the members were outside the community illegally. In as much as they were out of community illegally, it is still the responsibility of the institute to keep in touch with them in as far as that is possible. And in case they are not locatable or they have severed all the communication with the institute, that if they have been sought after by the authorities of the institute, or all efforts to locate them and be in contact with them have failed for that period of time, then we will go to one of the types of dismissal, which is automatic dismissal, which we will discuss in a short while. But it is different from a member who just disappeared and the competent superior just decide from nowhere. They are away for 2 years. The Pope said now anybody away for 1 year can be declared automatically dismissed. No, that is not correct. There's a procedure of dismissing such kind of members. It must begin by seriously looking for them to the point of exhorting them to come back and persevere in their vowed life. Because some would have disappeared out of anger. They do not want to submit to certain religious authorities. They want to escape from submission or from practicing their vow of obedience, or for whatever reason. So it is not correct just to dismiss them. That pastoral intervention is for validity of dismissing them. It has to be very, very clear that they were looked for by all possible means, and it can be proven that it was not possible to locate or communicate with them. And we'll discuss that when we are looking at automatic dismissal. So that cannot be termed as absence or exclaustration, but I would say that wherever the member is in the world, it is the obligation of the institute to look for them and to keep in touch. So I maybe Kelly, if you have something to add.
Just, I agree completely with everything you said, but that the attitude also is to seek that reconciliation, the rehabilitation of the member. She came, and we desire her to live in fidelity to the commitment she made. So whether it is in any of the processes of dismissal, or somebody who isn't faithful to whatever it is that they requested or is asked of them by their constitutions, that our first hope is that exhortation, that call back, in desiring them to renew their commitment that they made at profession, and especially perpetual profession.
And also, the authorities of the institute have to be wary of the member who keeps on wanting to renew, to extend the time. Their attitude is just to stay away. However much they finish the extension, they want another extension, or they have this and that excuse. Such a member must be put to task so that seriously they discern whether or not they would want to continue with their membership of the institute. Otherwise, it becomes a matter of one leadership after another. The member left 2 decades ago. They are still on this and that. I think it goes beyond, or it is even an abuse of charity, to imagine that such a member is still a pastoral approach of the relationship now they have with the institute. At one point, the leadership has to come round and say, what do we do with this matter? And the most important thing is seek for reconciliation and bring back the member to the fold as much as that is possible. And if then that is not possible, then other options are to be explored, because the behavior of the member is pointing to not wanting to come back as much as it would be desired that they come back.
And it's important to carry on and remind the member that she requested to live this life. She came and she asked, please, I wish to vow myself to God in the church and to live for my whole life according to these constitutions. So if she arrives at a moment that she does not or cannot live by these constitutions, nobody is forcing her to be here. She can leave. We are what is known as a voluntary society. And so she is not forced to remain. If she cannot or does not wish to live any longer the life that she committed to live in the constitutions, she can ask to leave. So it's important to remind our members that this is the agreement they asked to engage in, this agreement of living the constitutions or striving to live the constitutions. If she doesn't wish to do that anymore, she can go. But that exhortation to remain faithful to the commitment, and if it's not possible or not desirable, then she is free to go. And if she does not make that request of her own, then she will be helped. And I believe that's probably the next section for Sister Marin.
Yes. Okay. When we come to imposed exclaustration, the beginning, it is not the desire of the member. There might be a very grave reason, but the motivation is not from the member. For example, there is a ground that which the competent leaders of the institute would equate to qualify for dismissal. Let's say a member has violated the Constitution to the extent that they qualify for dismissal. Perhaps, like now, Book 6 of the Code of Canon Law has specified some of the criminal acts of stealing property, mismanagement of property of the institute. So grave that perhaps the member would qualify for dismissal. But in mitigation and in canonical equity and charity, evangelical charity, that the member, yes, qualifies to be dismissed, but we would want the member to have an opportunity to reform, also to turn around, to be remorseful and amend their ways. And the member is also remorseful enough to admit that what really happened is very grave, and they are ready to walk the path of reform or restitution in any way possible. In discretion or in consideration of everything else, the leadership may say, instead of asking the member to go or initiating dismissal process, let us impose exclaustration on him or her, and let us use that time to see if any restitution would be possible of the damage that has been done. In the spirit, I don't know whether it was the gospel of yesterday, that the one taking care of the fig tree said, no, let us give it another 1 more year to see if it can bear fruit. That could be, a way of imposing exclaustration. That could be one way that I can think of. That it is a lesser penalty than getting rid of the person altogether. Because maybe the person has been in the institute, perhaps they just got misled or they went into bad habits. And maybe if they are told to live outside the community, it will hit them and they will reform and come and carry on with their lives. So that could be one reason that I can think of. I don't know whether Kelly would want to add something on why or how,
For an imposed exclaustration, I usually see it as for those things that could be cause for dismissal, but because of the age or health of the member, it is lack of justice to or not helpful to dismiss them, that we still have the obligation to care for them, but it's a suspension of their right to live in community in the normal way because of their behavior, because of an illness, alcoholism, abuses. Oftentimes, yeah, that's usually the imposed exclaustration.
Okay.
It is a punishment, but it's for
less.
those cases, either they're not serious enough to merit dismissal, or the member we can't dismiss them because of age or health.
Yes, if they had initially taken the lengthy absence for more than 1 year and the necessity keeps on persisting, then they can request for voluntary exclaustration so that they have a longer time to respond to this, but it cannot be done by those in temporary vows. Those in temporary profession cannot enjoy or cannot be accorded this kind of path. It's only for perpetually professed. Yes. Any other question? Yes, they can return so long as that which they left for has been fully resolved, or they can be recalled by the competent superior. They can be recalled back before the time. Yes. Yes, they have the obligation because the reasons generally for voluntary might not be penal. They are not violations. Like, let's say somebody wants more time to care for a sick parent. There's nothing, the person just has a situation which cannot be fully accommodated by lengthy absence. So all those rights that they enjoy as members inside, they still do enjoy them, even when they are on exclaustration. But this has to be worked out in the decree. To what extent? Do they go with their salary? Do they bring in the money? Or sometimes they have no employment. How does the institute support them? Just like any other member. Yeah. It is okay, case by case, but as the question is, there's bad faith in the whole thing. There's the impression of bad faith. It's not in good faith. They want to escape, like they would like to escape the action that the institute is going to take because of the bad behavior. I would think that the competent superiors have to be very, very discreet in such a case whereby the person runs ahead to escape before they face the Constitution, as it were. So I think exclaustration has to be given its own merit. It is to be used for what it is and not what it is not. It is a vehicle that separates the person from the community to attend to something that is not compatible with living with others, not as a vehicle used to escape the wrath of the constitutions. I think that's what I would say about it. I don't know what Kelly would add there.
For me, it's so important to remember that exclaustration is a favor. The member has a right to ask for exclaustration, but their obligation, the commitment they made, is to live according to the constitutions for their whole life. And so they are asking for the favor to live outside of some of the exigencies of this commitment. They're asking for a favor. So the superiors, there is no obligation to grant exclaustration. It is a favor. So if, as Sister said, the motivation is not something just, that it is avoidance of either an assignment, I don't want to go there, and so I ask exclaustration. I don't want to be under this superior, so I ask exclaustration. I want to escape the effects of my bad decisions. No, these are not motives consistent with the purpose of this favor to help someone to be able to live their commitment. And so, as Sister said, it's important that we understand why the sister wants this time away and how she's going to achieve that, so that if she achieves her goal before the time is finished, she can come back. I recommend that this permission is granted annually to be renewed and not a big block at one time, so that after the first year, we can assess whether this has been fruitful, a good use of this tool to aid the member to be able to keep their commitment to consecrated life. So it's to remember that this is a favor. It's not, you are not obliged to grant it. And especially if the motivation is contrary to granting a favor.
Thank you, Kelly. And again, the competent superior is not obliged to say the member asked for 2 years exclaustration. The superior can give one. Yeah, just 1 year. It's not given as requested. It can be just 1 year, as Kelly has said.
And so, then they ask again at the end of the year.
Yeah, they can ask again. Yeah. Just say, you are hereby granted exclaustration for 1 year. If the necessity demands that it is asked for again, then it's fresh application. Yeah. Yes. Okay.
Thank you. Although we're not hearing you very well. Paula, I didn't hear you very well when you spoke. I wasn't hearing you.
Yes, we can receive. Yeah. I put my video. Oh, sorry. I'm sorry. And where's my PowerPoint? I can't see it. Try it again. Okay, just a minute. I share it. Here it is. Are you able to see it? Not yet. But I need to put it on. Yeah. Okay. So do we go to dismissal or we still want to go to questions? Okay. Thank you. So dismissal is a canonical procedure by which membership in religious institutes is definitively terminated. So it's usually a penalty. Otherwise, people will leave voluntarily, but dismissal is a penalty. And as such, it must be motivated by causes that are external, imputable, and juridically proven according to particular law of the institute and canon law. External in the sense that it is not just an intention. What has been committed is an external act of violation of the constitutions, not a plan or intention. Is imputable, that means the person who has committed the act is responsible for their action. That means they deliberately and willfully planned to commit the act. They ignored all necessary discretion, or they did not take other things into consideration. They committed it knowingly, purposefully, knowing even the consequences, and were negligent of all things that they could have avoided. And juridically proven, it means what they have committed, the act they have committed is specified in the constitutions or in the proper law of the institute and in canon law as violation of the obligations of vowed life. So all those must be taken into account when now the institute finally decides to dismiss a member. So in whatever process of dismissal, the rights of the member must be respected at all times. The member has a right to be heard, to access legal help, to enjoy a good name and reputation, their privacy to remain intact, and they have a right to upkeep and any other rights that they enjoy as members. Of course, certain rights may have to be modified depending, because sometimes the process might require that the superior access some information about them that touch on their reputation and privacy. But by and large, their rights have to be respected. So the competent authority of the institute to dismiss must put into consideration evaluation of the proofs that are gathered, their imputability, and must reach what we refer in canon law as moral certitude. They must reach the certainty that it is true the member committed the act and is guilty of it. Canon law specify technically 3 types, but I've included the 4th type that I will talk about. That is dismissal following an immediate expulsion from a religious house warranted by a particular agency that I will explain as we move along. So out of the 3 major forms or kinds of dismissal, the first one we have is automatic dismissal. That is Canon 694. We relate it with what happened at the Garden of Eden. By the very fact that Adam and Eve ate the forbidden fruit, they had earned themselves the penalty of being thrown off the Garden of Eden. God was not punishing them. God was just declaring that, I told you, if you do this, this will happen. So that is what is equated to automatic dismissal. And the law of the church has specified 3 reasons. The last one being added only on the 19th of March, 2019, which I already spoke about. That is the member who has disappeared to an unlocated place and has cut off all communication and cannot be reached for more than 1 year. So the 3 grounds are these. One who has defected notoriously from the Catholic faith. They have defected notoriously means they have done it in such a public and certain manner that so many people now know about it is public knowledge. The people defect from the Catholic faith either by obstinately rejecting the truths of the faith, denying, doubting the truths of the divine magisterium. So that one will include schismatics and apostates, those ones who separate themselves or deny communion with the hierarchy of the church, or those ones who do not, who openly reject or deny the teachings of the magisterium or the Catholic doctrine. We consider them to have defected notoriously from the Catholic faith. Maybe I could give you an example, like now a professed religious goes to the mosque and become a member of the Muslim community and even gets married according to the Muslim custom with the imam, the leader of the Muslim community. And there were so many people present that witnessed to that marriage and witnessed to the person now professing the Islamic faith. That one we consider them to have defected from the Catholic faith by their action. So other parts of canon law specify that such a person incurs an automatic sentence of excommunication. So when the law of the church has already attached a punishment of that gravity to the member, how can the superior now keep the member in the community, in a religious community, a juridic person, an entity belonging to the Catholic Church? Yeah. So it is not something that that can be given, much reasoning that you've already left the church and you still want to come and enjoy in part of the church. That's why it is automatic dismissal. Number 2, the second ground is a religious who has contracted or attempted marriage, even only civilly, going to the attorney's office to be married there. What this means, those who can contract marriage are those in temporary profession. They can marry validly but unlawfully because of the temporary nature of their commitment. But those in perpetual profession cannot, they are incapacitated, they are not able to contract marriage at all. What they do that in the public we see as marriage is just an attempt. They are attempting something they cannot do, that canonically is not possible. That's why it is either contracted for temporary profess or attempting for perpetually professed. So when a perpetually professed member attempts marriage, it is invalid, it is unlawful, and it is a ground for dismissing them automatically because they already have a bond, the bond of perpetual profession. They can now not validly have another bond. For the temporary professed, their bond allows them, they can get married, but it is illegal because they are professed publicly the vow of chastity, poverty, and obedience. The third ground, which I've already spoken about, is a religious who is illegitimately absent from the religious house, pursuant to Canon 665, paragraph 2, for more than 12 consecutive months. And a second condition is that where they are is unknown and no communication with them is possible. To prove this, maybe the institute only knows a telephone number, an email address, or their profile photo on WhatsApp or other social media networks, or a pseudo account or a pseudo address. So that one would qualify them to be in an allocated place. So that one also qualify for automatic dismissal or dismissal ipso facto by the very fact. Now we want to go to the process. How are these people dismissed? Do they just, the superior just takes a microphone and says, so and so is dismissed? All right, no. First of all, the major superior, I'm taking the scenario where the institute has intermediate parts like provinces or regions. So the delict or the action has been committed in a certain province or region where the member has disappeared. The important thing, the member must, from the onset, involve their counsel. That I want to initiate a dismissal process of this person who has disappeared. And as I said earlier, for the one that has disappeared, okay, let me go back a bit. I want to deal with the other cases, defecting from the Catholic faith and attempting or contracting marriage. The superior will collect the evidence. And the evidence, as far as is possible, because these are people that can be located, will be presented to the member to defend themselves. The superior will ask the member, this and this has come to our attention. What do you have to say about it? If their defense is insufficient and they cannot justify themselves, and the superior is convinced with moral certainty of the fact, the superior goes ahead, okay, and declare the fact that they are dismissal. In a context of council meeting, they'll vote the member dismissed, then communicate the fact. The superior does not need any confirmation from the Holy See or from the bishop of the house of assignment if it is an institute of diocesan right. Now, the specific process of this member that has disappeared for more than 12 months with whereabouts unknown. First, the first step, and time begins running when the major superior takes to action. So let's say they've been away for 20 years. Time will begin running when now the superior begins the process. The process, the first stage, seek out the religious. We said that the aim is that we are in one fold. People left home to come and live religious life and live it with others. They are vowed to follow the constitution. Seek out the member as much as possible. It could be the competent superior will use her friends to see if they can communicate, will try to trace them from the last known physical address, talk to people, even send the notice in the popular newspaper of lost persons. Up to that extent, so as to justify the fact that the person was, all efforts were made to trace the person. This has to be done repeatedly as many times as possible. It could even go beyond 1 year. The major superior is still just looking for the person and documenting all these efforts of attempting to communicate and to be in contact with the member. If all these efforts, let's say after 1 year, is futile, the person is untraceable, then only after that can the member now convene a council meeting, the competent superior, and declare the dismissal based on the fact that the member is untraceable and all efforts to locate him or her has been fruitless. For validity of the decree, it must be approved by the competent ecclesiastical authority. For diocesan bishop, for diocesan institutes, now it is the bishop of the mother house, the principal see, not the one of assignment. Because remember, the person disappeared. So if they were on assignment, that's a different thing. For institutes of pontifical right, the decree must be approved by the dicastery for it to be valid. Take note that this norm, this new ground, does not apply to cases that were prior to the 10th of April 2019, since the Pope did not say the law can be applied backwards. Okay? So you cannot say, oh, the person has been away for 3 years, let us begin. From 10th of April 2019, we start the process of looking for them. And then if they continue to be absent, is when now we follow that process. Again, I can imagine in your institutes, how many people arrived on the 9th of April of 2019? Only you can tell. Maybe people heard of the new law and they all arrived back. I don't know whether there's a question, but I would suggest, because of the interest of time, we look at all these kinds of dismissal, then we can put all our questions together, if that is acceptable. We go to obligatory or mandatory dismissal of Canon 695. This type of dismissal has become of great interest due to changes in Canon Law Book 6, because now some of the crimes that have been added have also modified the manner of the causes or the grounds for this type of dismissal. So the canon talks of several canons elsewhere, which maybe we don't know their content, and I will have highlighted their content so that we are not just seeing numbers, but a member must be dismissed for the crimes on those canons. And in a while, I'm going to highlight them. I've enumerated them. And even the ones that the member may decide know whether or not to dismiss if they can resolve the matter in another way. But this canon was also changed because earlier on, it only talked of the superior. But the people making the law of the church realized if we just say the superior, maybe the community leader is included. But it was corrected. The word major superior was added to mean either the regional, the provincial, or according to the proper law, usually it is the supreme moderator, the superior general. So I want to look at all those canons one by one that the canon has enumerated to give ground for mandatory dismissal. Mandatory dismissal means the superior is obliged to dismiss that member. If the superior does not do that, it is the superior now committing a crime. The superior must dismiss that member. One who is living in concubinage, yeah, I think we all understand the whole thing of concubinage. Number 2, that is Canon 1395, paragraph 1. Another reason for dismissing the member is scandalous contumacy in sin against the 6th commandment. Contumacy here means the person, after warning, after being rebuked, they just want to continue and continue. And their action is so scandalous to so many people in the ecclesial community. Perhaps they have a scandalous, which is very external, a relationship with a person, but people are able to determine this is something against the 6th commandment. Same with the second one, public scandal, sinful act of the 6th commandment. This one, when we look at now the documents on abuse of minors and vulnerable adults, it is expanded to mean that committing a scandalous sinful act against the 6th commandment with a minor below 16 years, or for a clerical religious below 18 years. And these are matters which we call sinful or criminal acts reserved to the doctrine, to the dicastery of the doctrine of the faith. Now, the competent superior is only collect the data, the proofs, and then the matter will be handed to the dicastery in Vatican to deal with it. I suppose we are conversant now with the process of safeguarding and then abuse of minors. Then other grounds is the use of force, that is removing one's freedom or threats, stealing fear, so that somebody is forced into acts against the 6th commandment. Another one on that canon, abuse of authority to commit acts against the 6th commandment, either intimidation, coercion, promise of money, and all that. So somebody abuses the authority. If you don't do this, I'll not promote you, things like that. And if it is a religious, that is a ground for dismissal. The next canon cited in that canon of mandatory dismissal are offenses under Canon 1397. These are offenses if maliciously committed, voluntary murder, abducting another by force or by fraud, that is selling to slavery or human trafficking, imprisoning another by force or by fraud, mutilating or gravely wounding another person, and if it is on, let's say, those who gravely wound the Pope or bishops, if they are priests, then they are not able to exercise priesthood, or they cannot be admitted to priesthood. They incur automatic sentence of suspension for bishops, and for the Pope, it is automatic sentence of excommunication. So if the church is already excommunicating that person, how can the same person be kept in the community? Then the other offense is abortion, procuring abortion, which is a sentence of excommunication. And abortion here includes those who paid for it, those who knew about it, those who cooperated, those who suggested. If they are religious, they incur the same penalty. Then another canon that has been mentioned, it is an elaborate one, so that if a superior needs to dismiss a member for this type of dismissal, mandatory, the superior must be conversant with these canons mentioned in that very canon, must understand them very clearly, and separate those actions that the superior can deal with and those actions that now have been remitted to the dicastery of the doctrine of the faith, notwithstanding the possible sentence of dismissing the member. So here, it is a case of mixed processes. The competent superior initiates a process of dismissal, but has to be aware that this kind of criminal act also have other authorities competent to deal with it. Like now, this one of 1398, it is a delict or a crime against the sixth commandment with a minor, a person who habitually lacks the imperfect use of reason, a person for whom the law recognized equal protection, like our workers, our staff, those who are vulnerable by the very state they are in. Yeah. Or to induce or recruit, that is grooming, or inducing to show themselves pornographically or participate in pornographic exhibition. A minor, a person who habitually lacks imperfect use of reason, or a person to whom the law recognized same protection. Or immorally acquire, possess, exhibit, or distribute any means of whatever technology, pornographic images of minors or persons who habitually lack the imperfect use of reasons. So we realize mandatory dismissal also go to the area of safeguarding. So here, the competent superior, when they are faced with this kind of criminal acts by members, have to proceed at best with advice from the competent church authority. It's not just simple dismissal of the member because of the harm such kind of criminal acts will cause to the ecclesial community. So the process is when the intermediate superior, the provincial, the regional, comes to get proof or comes to get knowledge of possibility of those criminal acts, they are to collect evidence. And when they are collecting evidence, it is important with the directives of the competent church authority to conduct what is called preliminary investigations, especially on matters that touch on abuse. They have to conduct the complete preliminary investigation canonically, which due to time, I don't think I'm able to go into that whole process. Even if they reach the moral certainty to dismiss the member, they must take into account the other procedures that have now been put by the church on how to deal with matters of abuse of minors, vulnerable adults, and those whom the law accords the same protection. So if the member is to be dismissed, the intermediate superior or leadership will forward the conclusion of their preliminary investigation to the next level. That's the level of the general leadership. So the general leader, the supreme moderator, will again weigh, because the member must be given time to defend, opportunity to defend themselves, to what extent the defenses of the member were sufficient, and what is the opinion of this intermediate leader and their council. So the leadership at the general level will further evaluate the accusations, the evidence, and the defenses. And if they feel that the member is to be dismissed, they collegially, what Sister Kelly talked about yesterday. At this, the decision to dismiss a member, usually it is a collegial vote, unless the proper law has stated otherwise. And it is required to break the tie that the councillors are 4, plus the supreme moderator, who makes them 5, so as to break the tie. So there are also cases in mandatory dismissal where the superior competent to dismiss may or may not dismiss. That is, cases involving sinful acts against the sixth commandment of minors, vulnerable adults, and those who do not have sufficient use of reason below the age of 16 or below the age of 18 for clerical religious. Use of force or threats to commit acts against the sixth commandment. Abuse of authority. Why these ones, there is discretion. First of all, I've explained that they may have to be remitted to the competent ecclesiastical authority to deal with them. So the competent superior may not have to dismiss because they will wait for the directives of the dicastery that now has competence to deal with this type of criminal actions. Alternatively, maybe after preliminary investigation, the competent superior in their judgment may think that the person may make amendments through other ways. There could be other remedial ways to deal with the matter. But as per now, I think the best thing when it is this kind of criminal acts to contact the dicastery for their directives without just merely saying they qualify to be dismissed and dismiss them. Now we go to discretionary dismissal. This is the last major type of dismissal. This is our whole list of obligations towards the vowed commitment, plus other things that touch on the faith. So, habitual neglect of the obligations of consecrated life, repeated violations of the sacred bonds, that's the vows, obstinate disobedience to the lawful orders of competent superiors in grave matters, obstinate attachment to or diffusion of teachings condemned by the magisterium of the church. Like the church doctrine is against abortion. Yeah, so if maybe there's widespread attachment to the fact that it is my body, my choice, then that would be, if it is verified, would be a ground for dismissal, or public adherence to materialistic or atheistic ideologies. Yeah, hedonism, adoration of our bodies, that I glorify the body more than even God, things like that. Then another unlawful absence in automatic dismissal, it is if it goes beyond 12 months and the person is unlocated. For this discretionary dismissal, it is up to 6 months. Beyond 6 months, now the competent superior can initiate a dismissal process. And the institute can add other serious reasons in their own proper law. For example, they can say, one who has mismanaged or is not able to account for this amount of money or this amount of funds, and they are guilty of it, could be dismissed. They could have had such kind of grounds. And there's the last one, a member in temporary vows can also be dismissed, even for less grave causes, because they are still on probation, they are still on testing. And if they are already committing all these violations, chances that they will only become worse when they are perpetually professed. That's why the legislator says even for less grave causes. Now the process. We imagine the process begins at the province or regional level. And discretionary means, in the judgment of the competent superior, they may or they may not dismiss. They may want to deal with the matter in another way. So it is a question of may, okay? Because they must have enough reasons to believe that the reason for dismissal exists. So first of all, they gather the evidence, yeah? So once they have gathered enough credible evidence that one of these violations has occurred, okay, they approach the member and as far as possible, have a pastoral remedy. What could be making the member to commit these violations? The member has to be accorded pastoral solicitude first. Renewal, change of apostolate, change of community, counseling, some spiritual account, as much as this is possible, but not be taken to Protestant prayer of exorcism or prayer sessions. Those are not pastoral remedy. Yeah. So we must also be according to the law. There are things that we cannot do as religious that take them to that healing pastor. The healing pastor will heal them. No. Pastoral remedy would be the solicitude that is within the law that can be accorded to the member. Then, if that is not yielding any fruit, the competent major superior will get the advice of the council and inform them that she or he wishes to initiate the dismissal process. The major superior may collect further proofs so that they are really certain that the case warrants dismissal. Then the member is called to defend themselves. No, they had already been called, sorry. Now the member is formally warned, and the warning will be twice. In between them will be 15 days, but my personal opinion, the days can be more, so as to ensure that the counting of time canonically is not compromised or is not used against the process, because the member will count and say there were only 14 days. So why not make it maybe 20 days? The contents of the warning letters are the same except for the change of dates. They must be signed by the notary. The person can be warned orally while the notary transcribes the content of the warning, but the superior in question must do it before 2 witnesses. And this must be transcribed for future reference. If it is written, it must be delivered in a credible and legitimate manner of delivering such kind of letters. What should the warning letter contain? Reasons for the warning, the facts. Yeah, reasons in law and in fact. The law says this and you've done this. And you've been asked to reform in this way. Then the action expected from the religious in a specified time. Therefore, you are expected to refrain from doing this by this time. If not, dismissal will follow if there's no amendment. That must be contained in the letter. The letter must indicate the right of the religious to have opportunity for self-defense, either legal defense, consulting a canonist, vicar for religious, or any other qualified persons, and also opportunity to have recourse to the supreme moderator and have direct contact with them and make their defenses to him or her. So that is the warning. I think I've talked about the warning. The procedure at the generalate level. So if all those warnings are futile, the major superior then will transmit the acts of the case, the warnings, the responses, everything written about this case, signed by the major superior and the notary. Whoever, one of the council members can act as the notary. And then all these acts will be transmitted to the supreme moderator and her council. And the member must be informed of the fact that now we are transmitting the case above. The member is still has a right to make appeal directly to the Superior General, even at this stage. But take note that once the process of dismissal has been initiated, it is not proper for the accused religious now to say, I want to leave the congregation, so that they want to avoid being dismissed, just like we are talked about exclaustration. On the side of the institute, it is also forbidden to force the accused member to go to psychological counseling or therapy as a way of threatening with the dismissal, as this will violate their human rights in Canon 220. So after receiving the acts, the general leadership proceeds by studying the matter. They will look at the proofs, the arguments, the defenses, and determine if it is indeed they warrant dismissal of the religious. I've said there must be at least 4 members, plus the general superior, the 5th one. They do a collegial vote in secret. Even though they vote collegially, only the superior general will sign the decision with the notary. And the decree of dismissal must contain in summary form facts in law, what happened, the law they have violated, and what the argument which has motivated the sentence to dismiss them. The decree issued in the case of a professed member takes effect from the time it is communicated to the member, unless the member has rejected it. So this canon was also modified by the Pope on 15th February 2022, that now superiors do not need to go to the dicastery or to the bishop to approve the decree of dismissal. It's an internal matter. It only becomes a matter of the external ecclesiastical authority if the member appeals. And I said the member can appeal within 1 month, and they don't need to do the remonstration. That is requesting the author of the decree to modify or change it. Effects of dismissal. So, for validity, the decree must indicate the right of the dismissed member to appeal to a higher ecclesiastical authority. So it is important in the letter to give the member the address of the bishop or the address of the dicastery of which they can refer their appeal to, and indicate that they have 30 days, 30 canonical days to appeal, which was modified, as I've said, 2nd of April 2023. So they don't need to make a request for modification of the decree. So the procedure at the dicastery, the procedure is now only on recourse, not on approval. So the documents that the superior has to send to the decree, maybe to the dicastery, the decree of dismissal is to be accompanied by 3 copies of neatly bound files containing all the acts of the case. Whatever happened in the case must be filed and catalogued. A covering letter from the competent superior, and their votum, the covering letter and the votum. The covering letter is to explain about the case, and then their own, the votum. Each one of them must write their own opinion about the case. Then the CV of the dismissed member, then the appendices of all the documents in the case. Handwritten letters have to be transcribed. A table of content, any other information the supreme moderator deems relevant to go to the dicastery or to the bishop, and the Holy See will follow their procedures according to its special law. Then the last form of dismissal, which is very rare. This is a case whereby the religious has caused such a grave scandal to the ecclesial community or threatening imminent danger to the members. Let's say a member is chasing the community members with a knife or with a gun, or is threatening to commit suicide. Such a member can be expelled straight away by the community superior. Not thrown to the street, but to a safe place whereby the member is safe and the community is safe. If the community leader cannot reach the major superior, that's when the law allows them to take action. But this must be followed by a process of dismissal, or the matter can be referred to the dicastery to get their directives on how to deal with it. The situation of temporary professed. There's a unique situation in canon law about temporary professed. The effects are the same as dismissal, but it is not dismissal. It is non-admission to final vows or to renewal of vows due to illness. So there are cases whereby a temporary professed has been ascertained that they are psychologically or physically ill. It doesn't matter when they contracted the illness. Either they came with it or they got it in the institute. Such a member can be dismissed or discontinued from making further profession, but on the following conditions. That illness exists is not the imagination of the superior thing, so and so is ill. That it has been ascertained by more than one expert, that is maybe medical experts. And the experts ascertain that this illness, the competent authority have ascertained that this illness renders the member unsuitable to lead the life of the institute. Either maybe the illness is specified as very infectious, or is going to take such a toll on the community and then the member, whatever. That has to be specified in proper law, and the competent major superior must get consent of the council before making the decision to non-admission to profession. However, a temporary professed member who becomes insane during that period can never be sent away. They remain in the institute indefinitely because now they cannot think. They are incapable of making any decision. Effects of dismissal: by the decree, the member loses all the rights and obligations deriving from religious profession. The dismissed member claims nothing from the institute and signs a document to the effect. However, the institute is to show the member equity and evangelical charity. These are people who have lived with us. They contributed to our life. We don't just throw them to the street. At least, depending on the provisions of proper law, we have to help them start life, their new status of life, in some way, not just fulfilling the law, but a help that even the institute will say, at least we'll help somebody, depending on how long they've stayed, whether they are going to manage life. Sometimes they are sick, sometimes they are advanced in age, and sometimes they have a very good job. So it will depend on the state of the person. Okay, so maybe I can stop there. Yeah, I can, because we'll leave the slides to the members, isn't it? Okay, and we have to appreciate that this was such a long thing. Okay. The process of dismissal is only in canon law, as much as I know. And even these slides we give are also very helpful. Okay. Yeah, thank you. Yeah, thank you very much for that. That is a nun, not a, nuns are different. So they mean the nun, eh? The nun in a monastery. Because sometimes there's the general balance of calling all sisters nuns. So I just want to get the clarity. Okay, the fact that somebody has secretly made profession somewhere, that is deceit. It invalidates the profession and the membership also. That's the quick answer I can give. Anybody who wants to live religious life in deceit, their status is invalid. No, because the law works in the external forum. It's very, very hard to quantify or to ascertain the effect or what witchcraft is, because it's something mystical. So that area is not covered by canon law. To the extent that it is ascertained that it has effect on the community. Let's say the person is violent, or the person, so it is those effects that will be used, but not the cause that I can say somebody is being dismissed for witchcraft, because it's something that cannot be quantified externally.
But if it can be verified externally, it is.
Yeah, from the effects, yes. I'm talking of the effects of that. Let's say somebody has witchcraft and then now he has come to beat somebody in the community.
But if they're seen practicing, if they're going to rituals, if they become.
If it is sustained, then it is a defect from the Catholic faith. You remember we talked about dogmatic
Exactly.
dismissal. They have repudiated. They are in repudiation of the faith. Yeah, they are in contempt of the Catholic faith. If it is proven, then that's a reason for dismissal automatically. Okay. Usually, institutes will have their own traditional practices of passing information. I think there's the balance between not violating the person's good name and reputation. So there should be a very charitable way of passing the information, but it's important that the sisters know. Yeah. Yes. Yeah. And I will, and sorry, Paul, I'll be, if you send me the questions, then I'll be answering them on the chat as the presentation goes on. Oh my goodness. Yeah. Okay. Yeah. 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 Yes. See you tomorrow. Bye bye. And thank you, everyone.
Ciao, ciao.
Bye bye.
Thank you so much.
Good, Marin. Thank you.
Apa itu nama baru? Nama itu